Welcome to our webinar, Aligning Investment and Climate Goals. Where does the Energy Charter modernization stand? First of all, on behalf of the organizing organization, CL, Climate Earth, and ISD, I would like to thank everyone for joining us today. And I would like also to thank all the panelists for accepting to discuss this very exciting topic. It's great to see there is so much interest in the topic. After 12 rounds of negotiations and one more coming up in May, the parties, the contracting parties are aiming to conclude the negotiations and reach an agreement in principle in June 2022 at an ad hoc Energy Charter conference. So this webinar aims to contribute to the debate by discussing the efforts that are made by the European Union to modernize the outdated treaty and to address its climate implications. We will have two panels today discussing the progress that has been achieved in the negotiations. In the first panel, we will have a moderated discussion with the panelists on the approach of the Commission to reform investment standards and tackle also the issues of compatibility of the ECT with EU law. In the second panel, we will hear from a keynote speaker on the ECT and climate change. And then we will have our panelists discussing and debating on whether the modernization process can help aligning the ECT with the objectives of the Paris Agreement, but also what alternatives exist. In that panel, if we have time, hopefully we will also be able to take questions from the audience, so you're invited to use the Q&A box below. There are some housekeeping rules before I hand it to our first panel. Feel free to use the rename function so that your screen name shows your name and your affiliation. Also, a kind reminder that this webinar is public and there is a recording of this session, so that is also available afterwards. If you would like to ask a question at any point during the webinar, please type it in the Q&A and we'll do our best to address it. There is also French and Spanish translation, and you can use the little button at the bottom right of your screen, the little globe symbol that should enable you to have the discussion in your language. So again, many thanks for joining us today, and I will turn now to our moderator for the first panel, Nathalie Bermasconi, who is Executive Director and Senior Director of Economic and Law Policy at ISD. Nathalie, the floor is yours.
Yeah, thank you very much, Amandine, and good afternoon, everyone. Welcome to this webinar with the title, Aligning Investment and Climate Goals. Where does the Energy Charter Treaty modernization stand? As you heard, my name is Nathalie Bermasconi, and I'm with the International Institute for Sustainable Development. I'll be moderating the first panel discussion, where we will discuss the approach of the European Commission on reforming investment protection standards and tackling issues of the Energy Charter Treaty's compatibility with EU law. I'm very excited to have a fantastic group of panelists today. We will first hear from Mr. Nikolai Kuplevatsky, who is a referendaire in the Chamber of the Advocate General Capeta at the Court of Justice of the European Union. We will then hear from Mr. Jan Gerrit Westerhoff, who is an investment negotiator in the European Commission's Directorate General for Trade, followed by Professor Lawrence Ankersmit, who is currently an assistant professor of European law at the Faculty of Law of the University of Amsterdam. And finally, we have the pleasure of welcoming Professor Christina Eckes, who is a professor of European law also at the Faculty of Law of the University of Amsterdam. And she's also the director of the Amsterdam Center for European Law and Governance. So as we've heard, the modernization of the Energy Charter Treaty directly relates to the ongoing discussion within the EU on the status and the future of investor-state dispute settlement and recent jurisprudential developments. In the landmark rulings of Achmea and Comstroy, the Court of Justice determined that intra-EU investor-state dispute settlement violates the principle of the autonomy of EU law. Also, in recent trade and investment agreements, the European Commission no longer includes investor-state arbitration and instead includes another type of investor-state dispute settlement, the so-called investment court system. The EU agreements also include new approaches to substantive investment protection standards. And in its current state, the Energy Charter Treaty is far from aligned with the EU's more recent investment protection approaches. The Energy Charter Treaty remains to date an outdated investment treaty with overly broad substantive protection standards that can potentially act as a barrier to climate action. The European Council has recognized these concerns and has mandated the Commission to negotiate a modernized Energy Charter Treaty that is aligned with the EU's revised investment law approach in more recent EU agreements. The European Commission has been putting forward proposals in line with the EU's new investment law approach in 12 negotiation sessions over the past 2 years. Now, one of the key questions we will be discussing today is whether the EU is succeeding in delivering on the modernization mandate. So, without further ado, I would now like to turn to our panelists. We have allocated 6 minutes for each of the speakers, and I will first hand the floor to Mr. Kuplevatsky, who will address the implications of the Comstroy ruling for the Energy Charter Treaty. What does it mean for the EU and its member states? And how did the arbitral tribunals take this new development into account or not? Mr. Kuplevatsky, you have the floor.
Well, thank you very much. I hope you can hear me well. Allow me to briefly state from the outset that, of course, I speak in my personal capacity and not in that of the court. Yes, as you rightly introduced, I will address 3 small issues or topics that I will address in the 6 minutes that I have. The first is the implications of Comstroy. The second, the direction of tribunals, and then what member states should do. Sorry, I see my video is a bit lagging, but I hope that doesn't affect the audio. Now, let me start with implications. Comstroy finds that Article 26 of the Energy Charter Treaty, that is the dispute settlement mechanism provision therein, is inapplicable between EU investors and EU member states. And so here the logic is quite simply an extension of Achmea, in the sense that this sort of dispute settlement is prohibited. But how to get there, the court slightly differed from its approach in Achmea. First, it reasoned that the Energy Charter Treaty is a bundle of bilateral obligations, bilateralized obligations between the signatories to the treaty, and thereby also between the member states. And then it went to the point of saying, well, actually, the member states don't even have the competence of agreeing to such a bundle of obligations among one another, if the result of that is that this new dispute settlement mechanism system falls outside the scope of Article 19 of the Treaty on European Union. So Article 26 cannot be applied between the member states. Now, because the court did not limit that part of its judgment in time, and that's a very important part of this whole judgment, because the court can do so, it has implications not only on future arbitrations, but necessarily also pending arbitrations, and also already concluded arbitrations where an award has already been handed down. And that's sort of the fruit of the poisonous tree effect. If there was never any competence to begin with to agree to this sort of system without making it incompatible with EU law, then as such, any results of that system can necessarily not be recognized under the legal system of the Union. But let me be clear on that point. Of course, the court did not find that the substantive provisions of the Energy Charter Treaty are incompatible with EU law. It's solely the dispute settlement mechanism provision. So the substantive provisions can continue to be relied on, especially before the European courts. Although, of course, there has been discussion previously that if the heart of such a treaty dies, what happens to the substance if the heart is not there to enforce it? But that's another question. Now, that brings me to the second point. What's the reaction of arbitral tribunals? In a certain sense, very similar to what happened in Achmea and what was to be expected. What you see in the press very often is the unnecessarily harsh reactions, the use of the dreaded I word, irrelevant. Comstroy is irrelevant, entirely irrelevant to a tribunal because it derives from a subsystem of international law that we, the tribunals, do not have to take into account. That's infracapital, the tribunal, which said that. And so those reactions are very similar to Achmea. But I think you also see a bit more reflective reaction when it comes to these latest developments. For instance, in Crook versus Spain, in that case, the tribunal said that it is regrettable, quite a different word already, that there's such a clash of Grundnormen, of foundational norms, when that clash arising from that subsystem of international law, which EU law as such is, could have been foreseen or was foreseeable if one knows EU law well enough. And so it is true, whichever way you look at, the bottom line is the same. And the bottom line leads to the same conclusion. We, the tribunals, have this mandate under international law. We will stick to that mandate, and we will reject the objection to that jurisdiction that has been put to us, so long as that mandate continues to exist. And frankly, I do not expect that to change. And then the reaction is, what do you do here? What should member states do? And I think there should be two broad courses of action. The first one naturally being proactive, right? The number one instinct here should be to update the declaration on intra-EU inapplicability between the member states, to finally have one single declaration collectively expressing the understanding of the member states. The masters of the treaties, they are still sovereigns, so that they can be used as a means of interpretation in pending arbitrations. But beyond that, I would actually prefer seeing an agreement between the member states, not a declaration, an agreement that basically expresses that 26 has been inapplicable all along, and that cuts any sort of uncertainty that might exist, or that does exist, obviously, in the international law realm. So a separate treaty that ab initio cuts those ties so that that mandate disappears. And the second course of action is more reactive. I think what should be done here is to apply for anti-arbitration injunctions in national and foreign courts. So very much like what the Netherlands has done in the Uniper case against Germany. And there's a second point that was raised recently by one of the agents of the Commission, and I agree very much that there should be tort claims against investors that commence such intra-EU actions after these Achmea and Comstroy declarations have been put out, or after these judgments have been put out, for violations of EU public policy. Because after all, that's what it is. Article 19 sets up a clear institutional and judicial system. If you seek to circumvent that system, you violate EU public policy. And with that, I thank you very much for your attention.
Well, thank you very, very much, Mr. Kuplavatsky. I guess we went right into the legal issues that we're talking about here. And I hope people are still following. It has been very clear, but also very, very legal reasoning and very clear kind of conclusions as well. So I think that this is a great starting point for our discussion. And I would like to now turn to Dr. Ankersmit. So Lawrence, long time no see. What are the main findings of your recent study on the compatibility of the Energy Charter Treaty with EU law? And we already had a little taste of what this might look like. So really looking forward to your views as well. Thank you.
Thank you, Natalie. And thank you for your introduction, and thank you for hosting us and organizing this event. It's really nice to see you again. And apologies for my voice. I've caught a cold a few days ago and unfortunately hasn't recovered yet. So we just heard a brief introduction of the issues relating to, let's say, the follow-up of Comstroy, which very much focuses on the member state obligations. Myself and Professor Eckes have recently written a study commissioned by Client Earth on the compatibility of the ECT with EU law, which very much focuses on the question to what extent the ECT is compatible with EU law in light of Opinion 117. So that also addresses the issue of, let's say, extra EU arbitration. And the main conclusion of that finding, and I realize we only have 6 minutes, so I'll try to keep it as short as possible, that the text as it currently stands of the ECT, we find incompatible with EU law. And I mean, that is to a certain extent no real surprise, given the fact that the ECT was negotiated in 1994. It's an old agreement and was entered into force in 1998. And only Opinion 117 was, of course, issued only a few years ago. And that is the opinion that really gave, let's say, more clarity on the issue to what extent investor-state dispute settlement mechanisms, such as the investment court system, can be compatible with EU law. So it's an extensive report. I can put it in the chat in a bit, the link to access it. But we basically focused on two main issues, and that is the issue of jurisdictional autonomy of EU law and to what extent the ECT, as the text currently stands, complies with that important principle. And secondly, the issue of regulatory autonomy, which is the autonomy of the EU institutions to adopt public interest legislation and the possible negative effects that tribunals might have by issuing awards and damages against the EU and its member states. So maybe just one step back, and I realize that yeah, it's a complicated issue, but the EU itself, as an international organization, is, in the words of the Court of Justice, an organization that has set up an autonomous legal order. So EU law is special. And that means that when the EU itself concludes international agreements in investor-state dispute settlement mechanisms, but all dispute settlement mechanisms set up by international agreements concluded by the EU need to respect, let's say, the special characteristics of EU law. And that in particular has to do with the jurisdiction of the Court of Justice and the way in which the EU treaties envisage how EU law operates in the EU, in particular, how it is uniformly applied and interpreted throughout the EU, and the way the EU institutions operate. So the problem with investor-state dispute settlement under the ECT and with Article 26 is that it provides an alternative recourse of dispute settlement to domestic courts, which are very important when it comes to the functioning of the EU's judicial system. The Article 267 of the TFEU sets out the preliminary reference procedure, which is the keystone of the EU's judicial system, and which makes sure that EU law is applied and interpreted uniformly throughout the EU. Well, by creating an alternative course of dispute settlement, the ECT basically allows investors to sideline that system of uniform interpretation and application of new law. And that's the first, let's say, major issue that we find with EU law that the ECT has, and that's, let's say, no surprise given opinion 213 in particular and opinion 117. The second issue is, I think, quite interesting and novel, and that really results from, let's say, the new case law in opinion 117, and that is the ability that needs to be protected, if you will, when the EU concludes international agreements, of the EU institutions to adopt rules that protect the public interest. And tribunals cannot adversely affect the way in which EU institutions go about this system. And we find that the ECT, given its expansive investment protection standards, and also given the broad scope of the ECT in terms of giving protection to investors, affects the autonomy of EU law in that respect as well. Simply put, the safeguards that the Court of Justice has pointed out in opinion 117 that were present in the CETA, the Comprehensive Economic and Trade Agreement between the EU and Canada, are not present in the ECT, and that's no surprise given that the ECT is such an old agreement. So yeah, in my talk, I just wanted to briefly outline what we have found in our studies. It's in our study. Of course, the discussion it's like invites for a much more like let's say detailed discussion, but I only have 6 minutes, so I'll refer to the study in the chat, and then perhaps Professor Christina Eckes can follow up with her.
Thank you very much. We already put the link in the chat, I have seen, so people who want to read up in more detail what was found, you can find that. But I think this has been very clear as well. So we've had two very clear interventions on quite complex issues, I might say. So thank you very much for that, Lawrence. I would now actually like to turn to Mr. Westerhoff. And Mr. Westerhoff, as part of the modernization process, the EU has made a number of textual reform proposals to align the Energy Charter Treaty with the Commission's new approach in recent EU agreements. So can you perhaps briefly explain what these proposals cover and to what extent the Commission is achieving these changes in the negotiations under the Energy Charter Treaty? The floor is yours. Thank you.
Thank you. Can you hear me? Good. Thanks a lot. Good afternoon, everybody. Thanks for the invitation. After two very clear interventions, I'll try to do my best to also be clear. I would like to talk about three different aspects. So basically, what is the modernization about, and the objectives of the EU and its member states? What have we proposed? And finally, indeed, what's the state of play? Where do we stand? So on the modernization of the ECT, what is it actually about? What kind of objectives are we striving for? First of all, I think it's about updating our investment protection standards and the dispute resolution rules, as already referred to by several speakers. It's an old agreement, and it needs terribly to be updated. Secondly, and that's our second objective, is to introduce clearer commitments on sustainable development, including on the clean energy transition, and then having in mind the EU's Green Deal and, of course, the implementation of the Paris Agreement. What have we proposed to reach those objectives. And maybe I should make two remarks up front. Is first of all, in advance of the negotiations, we had to agree with all the contracting parties what items could actually be discussed and could be up for negotiations. This is the famous or the infamous list of 24 items. So we are bound by that list. Secondly, for those who have not seen the proposals yet, in line with our transparent approach in negotiations, we have made all our initial proposals public, and you can find these on the website of the Commission, and more specific on the website of DG Trade. So we have proposed in May 2020 the following aspects, and I think you can divide it in several pillars. The first pillar is the modernization of the investment protection standards, and that follows very much our modern approach, as you can see in basically as of CETA up to our most recent investment protection agreement that had been concluded. So it contains an effort to get a proper definition of investment, a proper definition of investor, for example, to bring an end to mailbox companies using the ECT, clear rules on indirect expropriation, rules on public debt, which we think are very important nowadays in times of not only COVID, but also the situation in Ukraine. But besides that, most importantly also to move away from an unqualified provision on fair and equitable treatment. And last but not least, and I have left out a couple, of course, a right to regulate. So that's on the investment protection standards. Then on the dispute resolution related matters, we are not proposing a change to ISDS as such. I suspect there will be questions about that, so we can discuss that later. But we have tried at least to improve, let's say, the context by making proposals on frivolous claims, on security for costs, on transparency of the proceedings, and also on valuation of damages. Then the third pillar of the negotiations is about sustainable development. And there we have proposed to make reference of the implementation of Paris, but in more general terms, multilateral environmental agreements in general, and also the ILO convention. And we have tried to couple that with a specific dispute resolution system in the context of the ECT. The chapter on sustainable development also covers corporate social responsibility and, for example, provisions on an environmental impact assessment. So these were the proposals in May 2020. Then we made an additional proposal in February the year thereafter, and that deals with the definition of economic activity. And that provision somehow lays out the scope of the application of the ECT. And our proposal is also known as the so-called fossil fuel carve-out. And what does that mean? In a nutshell, basically, we propose no longer to provide for investment protection for new fossil fuel related investments. And we propose to phase out for existing fossil fuel projects in over a period of 10 years. That's the proposal that is generally or largely known as the fossil fuel carve-out. Now, having said that, where do we stand on all of this? Now, of course, I could entertain you for another 2 hours on where we stand and who said what, etc. But of course, I'm bound by the confidentiality of the negotiations. So let's not get into too much detail, but I'll try to do my best to give you a bit of a hint or a bit of a gist of what's going on. I think in general, we are making good progress overall, but we are certainly not there yet. And that's related to many different aspects. One of them being, for example, that we are dealing not only with consuming countries, but also with producer and transit countries. So countries, contracting parties with very different interests, contracting parties at a very different level of economic development, and of course also in terms of climate ambition. One smaller element which one should definitely not forget, we have had so far only one physical meeting. So we met each other for the first time after 11 rounds last week in Brussels. That was the first physical meeting, and you can clearly see that physical meetings have a completely different type of dynamics when it comes to negotiation. I think after 12 rounds, it's also fairly clear what the most contentious issues are, and they are and I don't think that will come as a surprise, the definition of economic activity, sustainable development, and within the context of investment protection, I would say fair and equitable treatment. And why is that? Because first of all, these are new issues for many contracting parties. These are issues that not only change the character of the investment protection, but also change the investment protection as such for certain investors. At least that's alleged by some of the contracting parties. Some contracting parties are foremost interested in protection of investors. Others want a more balanced approach, and there are also whose main interest is only the interest of the state. I think it's also because the EU approach is rather unique. If you look at FED, there's very few countries out there who have a similar approach as the EU in the context of fair and equitable treatment. A bit more specific on the three contentious issues. On the definition of economic activity, we had originally proposed this to be applicable to all the contracting parties. That was not acceptable. However, what has been accepted is a flexible approach in line with the Paris Agreement, whereby contracting parties can decide for their own territory and to what extent they carve out fossil fuel related investments from investment protection. We have that agreement on the table, but we are still working on the modalities. As regards FED, you can imagine that discussion is very much focused on the nature of the list of elements that can constitute a breach of FED. And with nature, I refer to whether it's an open or a closed list or some kind of a hybrid approach. The list of elements is also an issue of discussion, although less perhaps than the nature as such. Then on the last contentious issue, sustainable development, that is an area where I think from an EU perspective, we would like to see two elements appearing. That's not only that the sustainable development pillar creates self-standing obligations in order to implement the agreement, but that these self-standing obligations in the context of the ECT are also subject of a dispute resolution system under the ECT. That's for the contentious issues. I would say otherwise on the other aspects of investment protection, but also on transit and ISDS as such, we have to a very large extent agreed on many of the provisions, or are quite close to agree on those provisions. I certainly do not want to raise the expectation here that we are done, because there are indeed still quite some loose ends. And in that sense, I also should admit that we had expected by now to be a bit further, also knowing that basically there is one more formal round scheduled and one more formal round left for the whole procedure. But yeah, you have seen also maybe the public communication that was circulated by the ECT Secretariat on Friday. It appears that not everybody is ready yet to overcome the different aspects of this. So all in all, next steps. As I mentioned, we have an ad hoc conference planned by the end of June. Before that, still one more formal round left. That's at the end of May. And of course, in the meantime, we have very intensive bilateral discussions with the different contracting parties, because in such a setting of a plurilateral agreement, let's say the advances have to be made in a bilateral setting and are generally not made in such a plurilateral setting. So I would like to conclude my intervention here. Thank you.
Well, thank you very much. And certainly you were very clear as well. And I think everybody's very thankful how transparent the EU is being about these issues. So I think we're very thankful for the open intervention. And the structure is very clear, and also, sharing what are the contentious issues from your perspective, very useful. So thank you very much. I'm afraid we're going to be running out of time for the discussion, enough discussion, because this is so interesting and fascinating. But before we go to the discussion, I'd like to turn to Professor Eckes. Professor, what kind of action can the EU and its member states take if the EU fails to bring in line with the EU law in the ongoing modernization process? So I think we already have a little bit of an idea after the intervention so far but it would be great to get your view and your take on this.
Many thanks. Yeah, many thanks for organizing this. I find it highly interesting and I'm looking forward to the questions and answers and the discussion. So I will be very brief. I think we have indeed already gotten a sense of different aspects here, but nonetheless, I want to take one step back, and that I want to say in light of the ECT and as it stands now, but also in light of the negotiations as they're ongoing, I think it seems highly unlikely that the ECT would be in a modernized form compatible with EU law, because I don't think that even in the text proposal, as it stands, as was mentioned by the previous speaker, we would get a green light from the court if that was assessed, if it is assessed in opinion 120, for example. So I think in that unlikelihood, we should also emphasize something else, namely that the tensions are increasing. And I think that's another aspect that hasn't been highlighted here. The tensions between the ECT protecting the status quo and the European Union making considerable commitments to reduce emissions by 55% in 2030 as compared to 1990 levels, and such commitments that are expressed in clear legal instruments, there will be a tension, and that tension will be rising both for intra-EU arbitration but also for extra-EU arbitration. And also that line, of course, is not as static as it may seem. At the moment, the large majority are intra-EU arbitration, and that is, as we have heard, and that is well established, incompatible with EU law, but also there is possibilities to move both the seat of the arbitrator, but also the seat of the arbitration tribunal, as we have heard, to try to circumvent that prohibition. But in light of all this, and this was just a little prelude, let me get to your question, namely what should the EU do, what must the EU do, what must the member states do? And here I want, as a first point, highlight the loyalty obligations of both the EU and the member states, namely to act at all times in compatibility with EU law. And that is a firm obligation that the court has time and again confirmed, for example, in the previous BIT cases, namely the obligation to bring other agreements in line with EU law for the member states. But the same is in principle, of course, applicable to the EU institutions. So whenever there is such an incompatibility, there is a need for action. And then there are, of course, four possibilities. Amendment, as we have heard already, is on the way. We are in the course of discussions. Well, where does that lead and how long does that take? We are quite uncertain where we will end and how long it will take. As long as the negotiations are going on, as long as not 3/4 of the contracting parties of the ECT have actually deposited the instrument of ratification, the current ECT remains in place, which means as long as that is the case, new claims can be brought under the existing system. So here we are looking far into the future. But I mean, I don't want to speak more about amendment, we can do that later. The other option is, of course, withdrawal. The ECT foresees withdrawal, so there's no question, it's an international agreement that allows withdrawal, Article 47 of the ECT. The problem here is, however, the sunset clause, as we're all aware, so that claims can stay for 20 years into the future. And that makes withdrawal much less attractive. And that's also why the Commission has, for example, answered to the Parliament that it pursues further amendment because of this heavy long-term sunset clause. What can we do about that? One option we have already heard from Nikolai Koplevatsky is the declaration, at least for transparency, a unilateral declaration under the ECT. Such declaration exists. It has already been updated. The last is of May 2019, so long after the ECT has been concluded, but has entered into force, long after the EU is a party to it and the member states. So there is a possibility to update that declaration for transparency reasons and make very clear, A, that intra-EU arbitration is illegal, as was suggested, but also try to avoid the abuse of law, if you like. So the possibility to circumvent that illegality of intra-EU arbitration and make that very transparent that that is a breach of EU law and that there might be actions against it. Whether or not that might change the interpretation by arbitral tribunals is questionable, of course. It's a unilateral declaration, so one could, of course, raise the typical articles of the Vienna Convention on the Law of Treaties saying that you cannot unilaterally and retroactively change the content of an agreement. So it is an interpretation help, but it might not lead us all the way because Pacta sunt servanda, everyone has signed up for it. And the question is, how far will arbitral tribunals go along with it? In addition, we have the inter se modification, which I think is the most hopeful possibility. That is under Article 41 of the Vienna Convention on the Law of Treaties, the possibility between the member states, and that's, if you like, is the beauty of mixed agreements, that we have at the same time the EU as a party to the ECT and the member states, so multiple parties, that they can make an inter se agreement and basically disapply the ECT between them. They would also here have to be very clear that they avoid abuse of law by a change of seat of the investor, or by trying to go with intra-EU arbitration, so between an investor from an EU member state still having the seat in an EU member state against another EU member state outside of the EU trying to circumvent this. So there should be really clear clauses trying to limit that way of trying to circumvent that inter se agreement. In addition, and that is something that should be added here also, is that loyalty obligations do not only apply to the EU and to the member states, but also to national courts within member states. So in any event, national courts are bound not to give effect to intra-EU arbitration already as it stands now, but that could also further be emphasized, that that is the legal situation under EU law. In addition, and we have heard that already, we could bring actions against investors. I find that a very promising way, at least, to threaten that and try to avoid this circumvention of EU law. These are all different lines. I think the most promising is really the combination of making a clear declaration under the ECT, being transparent about the illegality, hoping that that will lead to a different interpretation, having an inter se agreement between the member states, and nonetheless withdrawing. Thank you.
Okay, also very, very clear. I think you raised so many issues that I had some prepared questions. I'm going to throw them out, and I'll go straight to Mr. Westerhoff to maybe respond to what Professor Eckes just kind of enumerated. Do you have any comments with respect to this list of what the EU could do to ensure compliance with EU law?
Thank you for the question. Yeah, that's a very broad question, as a matter of fact. I would maybe should have said thank you for the questions, plural. There's different aspects to it. I think, first of all, of course, we have every incentive to bring, with the modernization and the proposal in that context, to bring the ECT in line with EU law. There are several aspects to that. We have received from the Council a negotiation directive that we assume will bring the ECT in line with the EU law to the extent we can do so in this context. Maybe one other element that I would think is maybe also relevant when Professor Eckes referred to the withdrawal and the sunset clause. I think that's indeed a major impediment for a withdrawal. It's clear. That makes withdrawals indeed much less attractive. She referred to several options in that context, the declaration, the inter se agreement. I would tend to agree that indeed the inter se agreement in this context, but that is not only in the context of withdrawal, but that's also in the context of bringing an end to the intra-EU application is a good and most likely a very appropriate tool. What I missed there is, of course, that in terms of the intra-EU application and the question of how to bring an end to that, also in a way that tribunals will listen to that, is of course, we could also see whether there would be maybe a solution within the context of the EU modernization. That is an option that I did not hear. Thank you.
Well, that's I think excellent, and thank you very much for responding. And I do recognize that Professor Eck's, broad kind of conclusions also made the question very broad. So I hope you don't, you're not too angry with me, because I also have a quick follow-up question, which I think you already answered, but you mentioned that, you have the mandate, the negotiation mandate, and you also mentioned this list of items that you're allowed to discuss. And of course, I think that list of items is, of course, also a negotiated list. And so were there things that you would have liked to see on there? And do you think something's missing after all, if you wanted to say this is going to can be a modern outcome?
No, look, I would fully stick to the negotiating directives that the Commission received, and in that capacity, we are carrying out the task that the Commission received from the Council.
Right. Okay. And the list of items that of what you can negotiate, you think is broad enough to ensure a real modernization that allows you to align the ECT with your own priorities.
That was considered as broad enough indeed.
Okay. Okay. Thank you for that. I actually wanted to go back to I guess Mr. Kublowski, we heard that, intra-EU arbitration from you does violate EU law. And, my question is, can this problem that you identified be treated as part of the modernization process, or do we need something else? And I'm not sure if Nikolai is here because I can't see his picture, but I can see his name. Yes.
Yeah, sorry, I can't see you either, but I think somehow
the camera may be having an issue.
Yeah, I was trying to start and stop
very well, and we can see your name, so all is good.
Okay, good. As long as I'm not a cat, I think that then all is fine. I think so. Your question was essentially whether it would address whether, if I understood correctly, the question was whether the modernization process would address all the issues raised by the court, right?
Well, yes, the issues that were raised by the court, can they be addressed? Could they be addressed through the modernization process, or would that do other things have to be done, or can they be treated as part of that process? At least with respect to the ECT, of course.
Yes. Well, I suppose it depends on the mandate that is given to the Commission. As Jan Gerrit says, the Commission can only act within its mandate. If the Council, after political horse trading, decides that X, Y, and Z are the issues that need to be resolved, that are the consequences that need to be drawn from the directions that the court has given. I'm saying the consequences that need to be drawn, because that's a legal obligation on the EU institutions under Article 266. So if the Council decides that that is so, then that is at least the Council's position. The Commission is somehow stuck between a rock and a hard place, because on the one hand, it's supposed to follow the Council mandate. On the other hand, it is supposed to align everything with the court's directions, and that is not always easy when there's political discretion involved. You see that I'm trying to tiptoe around your answer, around your question, because I'm fearing that a question like that might reach the court at some point. So that I think it's a bit difficult to say right now in the abstract for me whether the modernization or the modernization mandate as it stands currently would satisfy all those requirements, in the hope that I am assigned that case in the future. But the point is that it is really, unfortunately, for the Commission, a very difficult situation, if I can say so.
Yeah, thank you for that. And we can't see you, so you could make a lot of faces and we wouldn't see it. So I'm sorry I put you into this position, but I think that the listeners and participants are really interested in this discussion and your response to this question. So thank you very much for that. I'd like to turn to Lawrence Ankersmit. And I was wondering whether you think there are, what are the legal avenues under EU or domestic law to force member states and the EU to take action and remedy the incompatibility of intra-EU investor-state dispute settlement based on the Energy Charter Treaty with EU law?
Yeah, thank you, Natalie. So when it comes to, let's say, an internal perspective, an internal EU law perspective, we have to be aware of the fact that, well, all acts adopted by EU institutions need to comply with the EU treaties. So that includes the Council's decision in 1998, the Council and Commission's decision actually, to conclude the ECT. Now, in principle, that decision can no longer be, let's say, directly challenged before the EU courts. However, it can be done so in an indirect way. So if there would be, and this is maybe what Mr. Kuplovansky is also referring to, if there is a remedy available before a domestic court, if there's an avenue available before a domestic court in which the question becomes relevant, whether that council decision to conclude the ECT is legal under EU law, you can have a preliminary reference. Then a domestic court, EU court, can you make use of that keystone of the EU's judicial system, the preliminary reference procedure, and can ask the Court of Justice whether the act of the EU to bind itself to the Energy Charter Treaty, to enter into that agreement, is legal under EU law, and that's certainly not excluded. We've seen it in the past that such questions have made it to the Court of Justice. It is all up to, let's say, what is possible under the different laws of the member states, whether there's an avenue. For instance, in the Netherlands, we know the Netherlands has some interesting options in that respect to determine whether such a question, it's up to the domestic court, of course, should go to the Court of Justice. And then you at least have clarity, full clarity on the question whether that decision is compatible with EU law. And then, of course, that means that the EU institutions will have to act swiftly under international law to make sure that the issue of internal incompatibility is addressed. So, of course, the EU remains a party to the Energy Charter Treaty in such an instance if the Court of Justice would invalidate that decision. But there's no, let's say, domestic act anymore that supports such a conclusion from an EU perspective. So that's certainly, I think, an interesting avenue. Like how that would work out, it really depends on domestic law. So you really have to look at who would potentially bring such a case before a domestic court, and to what extent then the court will consider it necessary to make such a reference to the Court of Justice. Sorry, it's a bit of a long answer, but basically it's really up to domestic courts and private litigants to see whether such a case would make it to the Court of Justice. And that, of course, will put additional extra pressure on the EU institutions to remedy the incompatibility.
Thank you very much for that answer. And I'm wondering whether your co-author wanted to add anything to this, Professor Eckes. No?
No, I think Laurens outlined this greatly. I think it's basically a task for you, for the civil society actors to take action, not so much for academics.
Thank you very much for that. I saw a question in the chat following up Mr. Kuplevsky's comment on the fact that investors could actually be sued and subject to a torts claim in case they were acting in a certain way that was counter what they knew was illegal under EU law. And I'm wondering if maybe any of you, I wanted to ask Mr. Westerhoff, but I've put him on the spot a lot. But if you would like to answer this, that would be very interesting for us to hear. if you want to pass, that's also okay. I would ask the academics to come in.
Sorry, was the question addressed to me?
No, I was picking that there was a question in the chat referring to your comment on torts. And I wanted to follow up on that question in the chat with Mr. Westerhoff, who I'm allowing to pass if he doesn't want to, and then I would want to hear from the academics as well. So.
Well, with all respect, I think the question was addressed to Nikolai in the first place. So, and he brought up this element, so maybe he could answer it as well.
So I'd be glad to answer it, given that I caused
also
trouble.
Good.
If I cause trouble, then I will also stand for it.
Okay.
It is so yeah. So the question was, so I made a comment saying, look, there has to be reactive in the sense that if a case is filed, an intra-EU case, and you see every week many cases filed. No, I'm going to say not many, but it's a regular occurrence that cases continue to be filed even after Comstroy, and especially after Achmea, also under the ECT. So a tort action is a claim to right a legal wrong, right? You have a civil wrong, you have a right, and you want that to be. I mean, you say before a court, this particular action is necessary in order to protect my right, or to right that wrong that was caused by that case, an intra-EU case. So the point here was, EU public policy has been recognized by the court and also by national courts, and I'll go into that in a second, as a separate sort of, I'm not going to say cause of action, but as a separate substantive argument. And so there's a case called Eco-Swiss. From Eco-Swiss, we know that the competition provisions in the treaty, the TFEU, constitute, so to speak, EU public policy. National systems have their own public policy provisions, but then EU public policy is sort of a new dimension. The competition provisions of the treaty constitute that, most likely. And I would be very surprised if it weren't. Certain provisions, other provisions of the TFEU, Article 267, the preliminary ruling mechanism that I think it was Lawrence that had alluded to it as the keystone of the dialogue between the national courts and the Court of Justice, but also other provisions, Article 19 TEU 344 TFEU, which is the "you shall have no court but me." Those constitute EU public policy provisions, essentially. Now, you can go before a national court, and you could say all national systems have some sort of tort action. In the French system, is more related to contract law, but it doesn't have to be arising out of contract law. And you say, this was violated now, and you will link that to either a prohibition to enforce an award, or to continue the case that arises separately in the before the arbitral tribunal. And that was alluded to by the Luxembourg Cour de Cassation in the Mikula enforcement proceedings, and which is why we get to this whole point, because there the Cour de Cassation said, well, what we are being asked to do here, enforcing this Mikula award, the intra-EU arbitration award based on a bilateral investment treaty, sort of represents, and they use the French terminology, the trouble manifeste d'un ordre public, a public order violation, and therefore we cannot enforce the award. And that is where the logic comes from. And this would be something that it has not been done further, at least to my knowledge, but this would be something that could be tickled out of the national systems.
Okay, well, this is very interesting and really exciting for lawyers to start thinking and talking about this. Unfortunately, we're already running out of time. So I think I have to start wrapping up. I guess one question I just wanted to ask all of you very quickly is, are we running out of time? So, and how fast, what's the fastest we can get to a solution, and in which way? Perhaps if you could just, give me a very quick answer, 30 seconds, what you think. Are we running out of time? And if so, what could we do to accelerate? Is the modernization process even possible to deliver something relatively fast? So maybe I can go back to Mr. Westerhoff now. and then I'll go to the other speakers very briefly.
Thank you. That's a challenging question. I think modernization is still the preferred option, and the modernization is most likely going to bring the fastest result. It may not be fast because it requires, of course, not only a conclusion but also a ratification of the modernization, and we are of course very well aware of that. The alternative being a withdrawal with a sunset clause of 20 years, plus the entire discussion between the different member states on a withdrawal as such, which is a decision on that is not a given. So we talk about more than just 20 years. I think that all in all, realistically and reasonably, I think the modernization is still the best way forward at this stage. Thank you.
Thank you for that. So now maybe going to Christina Eckes. The same question, maybe you can also build on Mr. Westerhoff's intervention.
Yeah, I'm much less optimistic with regards to the amendment. Of course, I'm not sitting in the negotiations, so I speak as an outsider. But looking at the duration in which the ECT will stay in force as it is now, seen that we could do, I mean, I understand that there's no political agreement between all member states, but as we have outlined, if there's an EU law obligation, I think there could be put quite some pressure on member states to move forward, despite the fact that politically, I also think we have seen signs of member states moving in the direction of considering withdrawal. So I don't think this is a static situation either. So I think a withdrawal in combination with an inter-se agreement saying that the sunset clause for the already currently illegal intra-EU arbitration does no longer apply would already lead us a long way, considering that the most cases, I want to emphasize that again, under the ECT are intra-EU arbitration. So I think clearly it is not a solution to all cases, but it would at least address a significant share of the current arbitration as we know it, and that with immediate effect, so much faster than negotiating for amendment, which, as we have heard, may still take a long time, plus ratification. We are looking into years into the future, potentially, or likely.
Yeah. Yes, thank you very much for that. Perhaps Mr. Kuplavatsky, would you like to say quickly your point of view before we move to the second panel?
Yeah, thank you. I do love a good legal case, and if the plurality of the national systems allows for a question to be put to the court, whether the mandate given by the council to the commission satisfies the obligations that it holds or that the union holds, then that would be I think a rather fast process to clarify whether we're heading in the right direction.
Thank you. And Professor Ankersmit to wrap it up.
Yeah, I think we're actually already out of time, given that we have these arbitrations like RWA and Uniper against the Netherlands. Just strictly speaking from a climate change perspective, I think very much over time. On the legality issue, I second what Professor Eckes has said. I think we need to move swiftly on multiple fronts to make sure that such agreements are compatible with EU law.
Well, thank you for that, Lawrence, and thank you to everyone. I'm not going to try to wrap it up because we don't have the time. I want to just ask for those to excuse me for not asking all the questions in the chats. Very sorry that we couldn't get to all of them. So thank you very much to all the speakers. And we're now turning to the second panel. So I think it's back to Amandine, right?
Yes, thank you very much, Nathalie, for moderating this first discussion. And thank you again to all the panelists. It's been very interesting discussion. I would like now to turn to Anaïs Berthier, who is the head of EU Affairs at Clan Earth and will moderate the second panel discussion. Thank you, everyone.
before I leave, I think Anaïs had muted herself.
Yeah, sorry about that. I had to unmute myself twice. So hi everyone, I'm Anaïs Berthier. I'm the head of EU affairs in the Brussels office of Planet Earth, and I'm really happy to be with you today. So I'll be moderating this second panel, which focuses more on the link between the ECT and climate change. So I think it's even clearer today after the discussions that we've just heard from the first panel that the Energy Charter Treaty has faced strong criticism in the recent years, also because it's seen as an obstacle to a clean energy transition. That's due to the fact, as we've also been hearing in the first panel, that the Charter still contains outdated investment protection standards, and that these provisions have been often interpreted in a far-reaching manner that has allowed foreign investors to challenge a wide range of public policies, and most recently, climate change policies as well, as we've seen, for example, in the Uniper case against the Netherlands for phasing out coal. So this inherent tension between climate change, climate and the ECT is not likely to disappear soon. On the contrary, it's more likely to increase given the fact that the EU has adopted and is still adopting a wide range of policies and pieces of legislation under the so-called European Green Deal to exactly carry out the green transition, but also to meet its international commitments to reduce emissions. So in that context, this panel will discuss the ECT modernization process and whether it can address that substantive tension and whether it can really align the ECT with the EU and international climate objectives, but also what are the options that are available and what are the alternatives to the current system, if any. So we are really happy to have with us Mr. George Kahal, who is a leading international arbitration lawyer, the chairman and the partner of the law firm Curtis, and who has already previously written and spoken about the problems and the dangers of ISDS, also from his perspective as counsel defending respondents in ISDS cases. And so who will give us the keynote speech. So without further ado, I'll give the floor to Mr. Kahal.
Thank you, Anaïs. Thank you very much. And I thank the organizers for inviting me to participate in this event. The relationship between the ECT, or let's say ISDS in general, and the climate crisis has become quite a popular subject these days. And I'm pleased to contribute to the discussion. And by the way, I'm really glad that I listened in to the very interesting discussion of the first panel. I really enjoyed that. I should acknowledge at the outset that I am not an expert on climate change, but I do know something about ISDS. Excuse me. From my vantage point as an active participant in the system, I've long found it to be deeply flawed and downright dangerous. And that's before the newfound interest in the relationship between ISDS and climate change. But this is not the occasion for that debate. What I would like to do instead is just highlight a few points that should be borne in mind when thinking about ISDS and climate change. First, you can be sure that investors and their counsel and third-party funders and their counsel are right now preparing to bring claims to challenge any governmental action addressing climate change that affects the bottom line, like what you've seen in the claims against the Netherlands for taking action to phase out the coal-fired power plants. You can see that just by reading law firm newsletters and the trade press. As one major firm recently wrote, ISDS is likely to be an increasingly important avenue for the resolution of climate disputes. They suggested that companies in industries most affected by states' climate change obligations should audit their corporate structure and change it if needed to ensure that they are protected by an investment treaty. They even noted that restructuring should take place before any climate-related dispute has arisen or is reasonably foreseeable. As some of you may recognize, that is a nod to the cases holding that restructuring an investment for no business reason other than to gain access to ISDS in anticipation of litigation may be considered treaty abuse. Finally, it was noted that some treaties have greater investor protections than others, and that it is therefore important to assess which treaty would best protect the company against climate-related measures. So in just a few short lines, we have treaty shopping issues, pointers on how to avoid treaty abuse defenses, and basically a battle plan to challenge state action on climate change. My next point is that there is little doubt that the fear of facing an ISDS claim has a chilling effect on state action. We don't need a lot of studies to tell us that. This is something I've been able to observe over the years in many contexts, not just climate. It's a fact that state officials are increasingly factoring the risk of an ISDS claim into their decision-making processes. This chilling effect has become more pronounced in recent years due to the proliferation of mega cases. Bad legal decisions are always unfortunate, but they can become calamitous when they lead to billion-dollar damage awards. Even if a claim is legally meritless, the very real possibility that a meritless claim will succeed, coupled with the sizable cost of defense, even where the claim is unsuccessful, is sufficient to create that regulatory chill. Third, from some of the proposals that I have seen, including, for example, revamping the ECT's definitions of investment and FET, clarifying the meaning of indirect expropriation and the often abused concept of MFN, and reaffirming the right to regulate, although frankly, I'm not sure why it's necessary to reaffirm such an obvious right. But there does seem to be at least a possibility of change in the right direction. Although I do find other proposals, such as the one on valuation, to be woefully inadequate and even counterproductive. In general, the proposed changes are along the lines of so-called modern investment treaties that are designed to curb the abuses we have seen from overly broad interpretations of broad language in the early treaties under which ISDS was created. In that sense, we should be grateful that the ECT modernization process, unlike UNCITRAL Working Group 3 that I'm sure you're familiar with, has not simply excluded substance from the scope of the deliberations. But if the track record of ISDS holds, in the end, there will still be plenty of risk with its concomitant chilling effect on governmental action. The final language will still likely have holes in it, and there will still be some tribunals that will render decisions that leave us scratching our heads. Something like what we saw recently in the Eco Oro versus Colombia case. And don't forget that there are 2,500 or so other treaties out there with ISDS provisions, including those early treaties that I mentioned. In sum, anyone hoping that the ECT modernization process will effect a sea change in the battle against climate change is likely in for a disappointment. I suspect there will be some movement on substantive clauses, such as the ones I mentioned, and some fluffy language about the importance of environmentally and socially responsible investment. That's all very good, but not likely to move the needle in the short term, even if the EU proposals are adopted. From my perspective as a participant in ISDS, I welcome any change as long as it's in the right direction, which means in the direction of curbing abuse, rather than encouraging the continuation of the development of investment law in the unsatisfactory manner that we have witnessed over the last quarter of a century. For me, that is not exclusively a climate issue. It's much broader. The fundamental question is whether states should retain the exclusive responsibility for addressing issues of public interest, including but not limited to climate change, or whether ISDS tribunals and the private participants in the system should be left to play an important role in shaping policy and determining the consequences of policy decisions. At bottom, the question is whether states wish to cede a significant portion of their sovereignty to ISDS tribunals, giving them the authority to decide which state measures taken in the public interest are legitimate and to award billions of dollars in damages for those they deem not to pass muster. If the answer is no, then the clearest and most effective reform of the ECT is the one thing that is not on the table, namely the deletion of its ISDS provisions. One final thought before closing. It's important to note that even if the ECT's ISDS provisions were eliminated, or as the EU advocates, replaced by a real court system, that would not mean that all states would take action addressing climate change. The point of scrapping the ISDS provisions is not to require states to take action. It is to remove impediments to states making their own policy decisions as to the actions to be taken or not taken. It's often said that states always remain free to exercise their sovereign prerogatives because no ISDS tribunal can force a state to adopt or refrain from adopting measures. But if the exercise of sovereignty comes with a billion-dollar price tag, the question has to be asked whether the concept of sovereignty has lost its true meaning. And with that, I will conclude my remarks and wish you a successful rest of the webinar. Thank you for your attention.
Thanks a lot. Thanks a lot for that very clear speech that I think sets the scene very well for the rest of the discussion, as well in relation to the risk and the threats that ISDS poses to as well climate policies, but not only. So now I propose that I give the floor directly to our 4 other panelists before starting the discussion and before taking questions. So we have 4 great panelists. So the first one will be Eleonore Deanzizou. She's a Paris qualified lawyer. She works at the Center for International Environmental Law, CIEL, where she focuses on international environmental law, human rights, and climate change law at the intersection with international investment and trade law. And so the first question we'd like to address relates to the use of the ECT by fossil fuel companies and the risk of regulatory chill that has just been mentioned. And so who are the important actors and what can be done to mitigate that risk? Eleonore, the floor is yours.
Thank you very much, Anais. Good afternoon, everyone. On behalf of CIEL, I would like to welcome you all and extend my gratitude to all speakers and moderators, as well as to Client Earth and IISD for their outstanding work putting this event together. Next slide, please, Lucas. So the question I have been asked to talk about today is also about, is the ECT an obstacle to climate action? And if so, how? And if you are not yet convinced by what George so rightfully pointed out, let me give you just a little more. Next slide, please. So first, let me highlight that the question is not entirely new. And I will take just a step back to provide some useful background regarding the general trends surrounding ISDS, and not only regarding climate change, but also regarding general environmental and human rights questions. As of today, almost 30% of all oil, gas, and mining cases have environmental components. And among these 30% of cases, there has been a growing number of investment claims brought against states in connection with the adoption of environmental measures, such as, for example, claims brought following the termination of a mining concession, which are due to environmental concerns of the government, claims brought following constitutional decisions to ban certain type of mining activities in protected areas, or, for example, there are also claims arising out of the government's imposition of additional environmental obligations. So the challenge is not new, but it is a trend that now is starting to move or shifting to climate change action. Why? Because climate measures could deprive investors of alleged economic value of their investment in fossil fuel activities. And previous speakers already mentioned some examples, as for example, RWE or Uniper against the Netherlands, which are under the ECT, but there are many more, as for example, the Keystone case in the US. So some of those cases are ECT based, some of those cases are not, but the ECT is definitely a key element in all of this, and I will come back to it shortly. Next slide, please, Lucas. Thank you. So did you say regulatory chill? So additionally to the fact that claims arising from climate action exist, another thing that is particularly worrying is what is happening outside the courtroom. The threat of investment arbitration has also discouraged policy action directly, as foreign investors have directly threatened states of using ISDS if a specific climate measure is taken. And I think about, for example, Vermillon against in France for French measures, or indirectly due to the general fear of states regarding the cost of new ISDS claims, as it was also provided by George just before. So some states such as Denmark, France, and New Zealand have openly admitted that they push back their deadlines to phase out oil and gas exploration or exploitation due to investment treaties and the fear of arbitration claims. And there might be more, but due to methodological challenges and data accessibility issues, it is impossible to quantify precisely how many regulations have been affected by actual claims or the threat of new claims. The chilling effect of ISDS is now nevertheless well established, and it has been mentioned in the report of the UN Working Group on Business and Human Rights, which was presented to the UN General Assembly last year, and I have put in my presentation a quote from that, or also it is mentioned now in the latest IPCC report, which just came out a few weeks ago. Next slide, please, Lucas. So why is the ECT so important? Because the ECT is a plurilateral agreement specifically dedicated to the energy industry compared to other agreements, investment agreements, and it binds more than 50 states. A big majority of investment agreements are actually bilateral. So in this case, 50 states, it's quite significant. It is also the most frequently invoked international investment agreement in ISDS disputes. And additionally, some provisions are of particular concern, and I will mention two now and one in the next slide. So first, for example, if we look at Article 10 of the ECT, which obliges states to provide investor fair and equitable treatment, and it has also been mentioned in panel 1 and by George, which is also understood by ECT tribunals to include the protection of investors' legitimate expectations, which, by the way, it's originally an artificial construction brought by ISDS tribunals, and which means that states are required to maintain a certain degree of stability and predictability in the regulatory framework. It's a bit more complex than that, but just to simplify a little bit. In the context of climate change, under this article, investors have argued already that they relied on energy policies that were in force at a specific moment, where maybe the state was not mentioning specifically phasing out measures or other type of climate measures. Additionally, Article 13 of the ECT not only deals with the prohibition of expropriation, which is the taking of property by the state, but it also covers measures having effect equivalent to expropriation, or so-called indirect expropriation, which raises the issue of the application of Article 13 to regulatory measures that affect a foreign investment. Next slide, please, Lucas. The EU has adopted a range of instruments in order to create a legal framework to achieve the objectives of the European Green Deal and its international commitments of reduction emissions, for example, the Paris Agreement. These instruments include, for example, the EU climate law or the EU emissions trading system, among others. Unfortunately, it is unlikely that arbitration tribunals established on the basis of the ECT will allow respondent states to justify their actions due to their EU law obligations, simply because, or even international obligations, simply because arbitration tribunals are not bound by the primacy of EU law. And if they were, the application of EU law will still depend on whether the substantive protection provided by EU law is more favorable to investors than are the investment protections of the ECT. Today, as provided in a report published by Climate Change Council, we know that no tribunal has considered international climate law or EU climate law when interpreting the ECT investment protections, nor in general, nor in the particular context of intra-EU cases. The only other treaty that ECT tribunals have considered is the Treaty on the Functioning of the European Union, TFEU, and following the application of Article 16 of the ECT, which stipulates that the investors' protection prevail over conflicting provisions in other treaties, in a large majority, if not almost all but one, of the cases, tribunals have found that the ECT prevails over EU law. Next slide, please. So our textual reforms propose likely to prevent regulatory chill and reverse or address that supremacy of investment norms over environmental objectives. As it was shared before in the first panel, the European Commission has made text proposals for the amendment of the ECT. I don't have time to cover this in full, and I hope that other speakers will also speak a little bit about it, even if it was already quite covered in the first panel. But shortly, I will make two practical reflections. The EU text proposal of May 2020 does not propose to amend Article 16, which I just mentioned was quite problematic. And the effectiveness of some amendments, for example, the one on the inclusion of the right to regulate or the definition of indirect expropriation, will still depend on tribunals' interpretation. So the effectiveness of that proposal in part is yet to be seen in practice. And as George pointed out, also, for example, with the case of Ecooro, sometimes tribunals tend to do interpretations that are more favorable, not necessarily to say to investors, but that don't maybe take into account environmental considerations at its core. Next slide, please. So with that, I just wanted to thank you again. I'm done with my presentation and open for questions. Thank you.
Thanks a lot for that very clear and detailed presentation. I suggest we move on to the next presentation, so we are sure we have the time to listen to all the speakers and then have questions. And so our next speaker is Lucia Barcena. She's a Spanish-Mexican researcher and campaigner who specializes in the European Union's trade and investment agenda and the international investment regime. She is also part of the Economic Justice Program in Transnational Institute. And so Lucia will take us through more of a case study on the use of the ECT by the renewable energy sector and the ISDS cases that have been brought against Spain. And we'll tackle the question whether we can really argue, and I think we have the beginning of an answer, whether we can really argue that the ECT can be a tool for the energy transition. Lucia, the floor is yours.
Yes, so thank you for inviting me, and good afternoon or good morning, depending on where you're listening from. And first, I think what George said is really the case that I will present in Spain, because rather than an example of renewable companies finding some kind of remedy in the ECT, it's really an example of abuse of the treaties protection by these transnational investors. So first, to give a little bit of a context, in the last 10 years, Spain has been subject to more investment arbitrations than any other country. It has received a total of 50 claims, of which 26 have already been resolved, 21 of them in favor of the investor. This means that around 80% of the cases are resolved in favor of the investor, which is way above the average, and is in a way also has led to Spain being a very attractive country to initiate arbitration awards. The case of Spain is also noteworthy because all the proceedings have been initiated by transnational investors over the same regulatory measures. The investors claim that Spain has treated them in an unfair and unequal manner after the government made several changes to the renewable incentive schemes from 2007. But the story is not so simple. First, the changes in policy did not happen from one day to another. Between 2008 and 2014, more than 20 decrees were approved. And in fact, most of the transnational investors today suing Spain under the ECT only started investing after 2008, so where the changes have already been happening. Secondly, for the government at that time, the anticipated explosion of photovoltaic installations would have put in danger the electric system and cost an extra $2 billion in a moment of crisis. And so the government made a choice to cut its subsidies, in theory, at least to alleviate the consumers and taxpayers from the extra costs during a time of crisis. So there can be criticisms on the government's decisions and indeed poor policy planning, but these decisions were taken in their sovereign capacity and lessons have been learned. In any case, beyond the discussion on the changes to the renewable energy incentive schemes, the ECT has only benefited a very specific type of transnational investor and also law firms at the expense of Spain's solar dream. So firstly, the ECT overwhelmingly benefits financial and speculative investors. 89% of the beneficiaries of ECT claims are financial corporations and investment funds that have little or nothing to do with a sustainable energy transition. In fact, many only invested in the Spanish renewable sectors because of the above market returns at the time of buying the existing installations. Half of these companies who in Spain actually also have investments in the coal, oil, gas, and nuclear energy sectors. So in fact, while investing in renewable energies, they have been pouring money into fossil fuel projects elsewhere at the same time. Secondly, Spain is diverting significant resources to pay these investment arbitration awards, and lawyers and arbitrators too. So far, the Spanish state has been ordered to pay 1.1 billion euros in compensation for the cases it has lost, which is 5 times what it planned to spend to alleviate energy poverty in 2021. Thirdly, the ECT claims have actually created a discriminatory system.
Lucia, sorry,
only large foreign investors or Spanish investors with foreign subsidiaries or mailbox companies have recourse to international arbitration. This shifts money and power towards big corporations and transnational investment funds at the expense of businesses in Spain and other national groups of investors, SMEs or energy cooperatives, who are important agents for a just energy transition and actually account for 75% of investments in renewable energy in Spain. And finally, the Spanish case demonstrates that the standard on whether the investors have a legitimate expectation over regulatory practice from the state has been set at a very low level, which has been very much more favorable to the investor throughout. As such, the ECT has now been used as an all-risk insurance to reduce the regulatory risk that the investor should assume with their due diligence. And this actually leaves Spain in a very vulnerable position, since it can easily face new lawsuits when it accelerates its phase out of fossil fuel plants, for example, or limits the prices of electricity, as example of policies that are actually currently being developed. Thank you.
Thanks a lot. I hope it was only my connection that was not working properly and not the others, because I couldn't hear everything of the presentation, but I have the impression that it was only mine, so don't worry. Thank you for that, really, that more concrete example of the way the ECT can be implemented as well and used by investors. And now the next speaker is Lucas Schauk. He is an international law analyst of the investment law and policy workstream at the International Institute for Sustainable Development. And in his work, he focuses on the ECT modernization, the ISDS reform at UNICITRAL, and the reform of the international investment agreements in general. And so, Lucas, is the proposal of the EU phase out of fossil fuel investment protection an effective solution to reduce the risk of litigation, or would a withdrawal from the ECT be more promising from a climate perspective?
Yes, thank you very much, Anais, and good morning, good afternoon, and good evening, everyone, depending on where you are joining us from. So at the outset, I would like to also expressly thank George for his excellent keynote speech, which, frankly speaking, in and of itself doesn't leave many questions open. But I shall nevertheless try to make a contribution and answer your question as briefly as possible, Anais. So the facts are clear. When it comes to tackling climate change, we have literally no time left and need to act now. The last IPCC report, as has been mentioned by Eleonore, has specifically mentioned the Energy Charter Treaty and ISDS as obstacles to the clean energy transition. It is also clear that this decade is decisive for climate action, and as governments take increasingly bold steps, regulatory changes are likely to have a major impact on fossil fuel investments protected under the Energy Charter Treaty. So just to give you two quick examples of the orders of magnitude that we are talking about, there are currently at least 61 coal-fired power plants that are protected by the Energy Charter Treaty, and the overall fossil fuel infrastructure protected by the ECT has been estimated to exceed 345 billion euros. So the question of reducing the litigation risk based on the ECT is a pertinent and an extremely pressing one. In its proposal from early 2021, the EU has suggested that a definition of energy materials and products in the treaty be revised, and it suggests a distinction between existing and future investments. According to the proposal, the EU suggests that existing investments remain covered by the investment provisions of the modernized ECT for a period of 10 years after entry into force or provisional application of the amendment. So this means that investors of existing fossil fuel investments, including coal, oil, and gas, may still bring ISDS claims for a period of 10 years after such date. This means in practice that potentially all the fossil fuel infrastructure of 345 billion euros could eventually become the object of an ECT-based ISDS claim. Moreover, the EU suggests that future investments in fossil fuels be excluded from the coverage of the treaty, but it suggests also that there be broad exemptions for future investments in fossil gas, hydrogen, and certain gas pipelines. All these exempted investments would also continue to be protected for at least 10 years after entry into force or provisional application of a modernized ECT. As we have heard in the first panel, this all assumes, of course, that an amendment can actually be passed. Now, this means, of course, that up to 53 contracting parties would have to take a unanimous decision to pass the amendment. Reluctant parties or parties with improper motives, as is possible in the current political climate, could therefore thwart the amendment procedure by presenting a veto even at the last minute. Even if the amendment is passed and safe for a provisional application, it would only enter into force if more than 3/4 of all contracting parties ratify it. And even then, it would only enter into force among those contracting parties who do actually ratify. So you see that even if the EU proposal is accepted and adopted and enters into force, we're talking about a very long timeline here. So what would be the litigation risk in case of a coordinated withdrawal of the EU and its member states? Such a withdrawal is possible according to Article 47 of the ECT, which states that a contracting party may withdraw from the ECT by serving written notice to the depositary. The withdrawal will take effect 1 year after receipt of the notice. But as we all know, such a withdrawal would trigger the sunset clause of the treaty, which stipulates that the provisions of the treaty shall continue to apply to existing investments for a period of 20 years after withdrawal. Of course, the sunset clause only applies to existing investments, and as opposed to the EU amendment proposal, a withdrawal would immediately stop protection of any future investments upon taking effect. Furthermore, the withdrawing states could neutralize the sunset clause among themselves by concluding an inter-se agreement, as has been mentioned during the first panel, to the effect before withdrawing. If the EU and its member states concluded such an agreement among themselves, this would almost entirely eliminate the litigation risk in relation to existing investments as well, as most ISDS proceedings based on the ECT are brought within the EU. So to conclude, a coordinated withdrawal of the EU and its member states in combination with such a neutralization of the sunset clause among the EU member states could almost entirely eliminate the ECT-based ISDS risk, whereas in contrast, the EU amendment proposal, even if adopted, would allow existing and certain future fossil fuel investments to generate ISDS risk for at least another decade. And with that, I would like to hand back the floor to Anaïs for the next presentation.
Thanks for that really clear presentation as well, and for a start of a proposal for an alternative. So there is maybe hope. Next speaker, Martin Dietrich Brausch. He's an international lawyer and economist working as senior legal and economics researcher at the Columbia Center on Sustainable Investment at Columbia University in New York, where he focuses on climate-friendly sustainable investment policies and practices, and particularly in mining and energy. He leads the CCSI's cross-cutting work on climate investment policy. So Martin, what would be the key features of a modernized ECT from your perspective? And what are the alternatives to the current system? Thanks.
Thank you very much, Anais, and thanks to CL, Client Earth, and IISD for inviting me. I'm thrilled to participate today. Like other treaties centered on investment protection and arbitration, the ECT is fundamentally misaligned with climate action and other sustainable development goals, or SDGs. Investing in the transition away from fossil energy and toward zero carbon energy is essential to achieving climate goals. But there's no conclusive evidence that investment protection or ISDS can increase the investments needed for this transition. A modern ECT would instead focus on investment governance in line with climate action and other global goals. It would shape and regulate climate-friendly energy investment, phase out fossil energy investment, and ensure a just energy transition. So first, to advance zero carbon energy, the ECT could contain guidance and commitments by states on how to regulate energy investment in line with climate action. It could foster international cooperation, research and development, R&D, and financing mechanisms for climate-aligned energy investments, including in energy efficiency, renewable electricity, climate-resilient grids, green hydrogen, and battery production and recycling. The ECT could establish cooperation mechanisms to address challenges in the governance of transnational energy investment, including intellectual property and technology transfer issues. And it could not reaffirm, but strengthen states' rights and duty to take climate action by supporting domestic administrative and judicial systems to facilitate investment regulation and enforcement. Second, let's talk about the dinosaur in the room, fossil energy investment. Fossil energy companies have known for decades that they're the major sources of greenhouse gas emissions that interfere dangerously with the global climate system, in the words of the UN Framework Convention. They've also long known that successful climate policy must affect their profits and business. They have resources to insure themselves and to diversify by investing massively in zero carbon energy. But instead, as a sector, they've recklessly continued to invest in fossil fuel extraction and additional exploration, deliberately disseminated misinformation about climate science, and lobbied against domestic and international climate policy. A climate-aligned ECT wouldn't focus on confidential negotiations on whether those companies should benefit from international law protection until 2030 or 2040. And it wouldn't empower private arbitrators to decide behind closed doors how much compensation those companies should receive because they were affected by legitimate climate policy. Instead, states would adopt binding commitments and timelines to phase out investment protections and incentives for fossil energy, including fossil fuel subsidies, and to phase out those fossil energy investments themselves according to a Paris-aligned pathway. States could also establish principles and criteria on any compensation that fossil energy companies might be paid. At a minimum, any payment should be conditioned on the explicit prohibition of reinvesting it in fossil energy and infrastructure, and conditioned on specific enforceable just transition obligations on the company for the benefit of its employees. And this brings me to my final point. The ECT could create mechanisms in a forum for international cooperation on a just energy transition within and between countries. It should protect the rights and meet the needs of states and populations who are most vulnerable to climate and energy transition risks and costs, who can't afford to bear those risks and costs and therefore need help. The treaty could define principles and criteria to protect workers affected by the phase out of fossil fuels, who will need severance packages, social safety nets, resources and opportunities for retraining and upskilling. States could also cooperate on how to reduce disproportionate impacts of the transition on other local and indigenous communities and broader populations and taxpayers. The ECT should also include transparency, accountability, stakeholder participation, and other procedural justice mechanisms to ensure that the voices of those affected and vulnerable are heard and their rights realized. States could commit to translate those principles and criteria into domestic laws and mechanisms, such as just transition commissions or task forces. A just transition is also about global energy justice. Lower income countries have the lowest levels of energy access, are the most vulnerable to climate and energy transition impacts, and have the least access to public finance, including for energy investment. The ECT could set up financial commitments and mechanisms to ensure, that all states have adequate resources to invest in zero carbon energy, to contribute to both climate action and universal energy access. It could also commit higher income countries to pay lower income countries to keep fossil fuels in the ground and invest in zero carbon energy instead. To conclude, a modern ECT should look less like a treaty on corporate privilege and more like an energy charter. Like the UN Charter is the founding treaty of the United Nations, an ambitious ECT from a climate perspective would be foundational to a just, climate-aligned global energy system. Thank you.
Thanks a lot, Martin. And thanks for these great proposals on how to modernize the ECT. Let's hope the European Commission and the member state hear you. So now I'd like to offer the other panelists the possibility to get the perspectives as well on the alternative that exists, but also if you want to react to the keynote speech that has been given. And also if you can share your thoughts with us on what we really need to support the clean energy transition and to ensure that the EU and the member state achieve the Paris objectives. So maybe we can start with Eleanor.
Sure, thank you very much, Anais. Some thoughts. I think for sure having a full reform of the system by taking out the problematic treaties or changing them in a way that they are enough reformed, I would say, what I would suggest would definitely be welcome. On the time, knowing that we have short time, the IPCC report said that we have 3 years to start lowering our fossil fuel emissions. What can we do also in the meantime? And my concern is also about how can we neutralize ISDS, at least for some type of activities? How could we maybe stop providing protection under these treaties that have ISDS clauses for fossil fuel companies that we take these measures? Is there something else we could do? Maybe reinforcing, how to say, like we have, at least in many treaties, we have provisions that provide environmental exceptions or exceptions in general that should protect the state regulatory space that he has, but often those clauses are not very well interpreted. So one thought I have been taking for quite a while is why we're trying to change the system, and it's going to take time and it's needed and we have to do it. While we do that process, what can we do with the current system as it is? Because claims are here right now. So is there a way to try to say to arbitrators, the tribunals that are currently in cases related to fossil fuels? And I would say also that the fact that climate change is so urgent and that at the same time we are right now so much like it's established everywhere. Everyone knows about climate change. Maybe not everyone believes about climate change, but it's at least a topic that is of discussion. Also impacts on us not having a look and maybe giving more momentum to other type of cases, for example, in the mining industry, and sending that back to renewable energy, where we also need to extract for renewables, but mining activity is also affecting communities in many, many places. At CL, we work on cases in Latin America, for example, which are highly concerning. So how do we neutralize the impact of ISDS with the current system as it is right now? Is there a way to reinforce the provisions that are there already, like environmental exception clauses? Is there a way to persuade arbitrators that are deciding that they have maybe to do it a bit differently than what they're doing? I don't know. Those are some questions. There's no clear answer. There's many things we need to do simultaneously. And part of it is maybe some of that as well. Yeah.
Thanks, Eleonore. Lucas?
Yes, thank you very much. That's a very interesting question. Now, I am not an expert on climate change and specifically climate policy, and would not dare to venture too far beyond the realm of investment law and what investment law can do to support the efforts of states to tackle the climate crisis. I would, however, like to recall an excellent phrase that George chose in his keynote speech. So if sovereignty comes with $1 billion price tag attached to it, maybe we have to rethink what sovereignty really means. And I think that is really the key issue here when it comes to ISDS, and more specifically, the Energy Charter Treaty modernization. In light of this, I think that the only possible avenue open to the EU and its member states with regard to the Energy Charter Treaty is a coordinated withdrawal. We have shown that a coordinated withdrawal has a solid basis in public international law. This could also involve the neutralization of the sunset clause, and there are precedent cases for neutralization of sunset clauses in other international investment agreements. In addition to that, there have already been quite a few hopeful signals by the European Union member states, such as France and Spain, and even some initial thoughts on a possible withdrawal by Greece and Denmark, that they are no longer ruling out such a withdrawal. So with regard to the ECT, which is currently the international investment agreement that generates the highest number of ISDS cases, and a significant number of those cases actually relate to the fossil fuel industry, I think a coordinated withdrawal is now the best avenue, and that is definitely what we as civil society, but also policymakers and academia should pursue.
Thank you. That's very clear. Lucia, do you want to react to any of that?
Well, yeah, I mean, I would like to go back to the Spanish case and the renewables case, just to also maybe raise the question or the issue that while there is a very clear evidence of the negative impacts that the ECT has had, reference to the ISDS cases, there is really no clear evidence that the ECT actually attracts investment in renewable projects. As we've seen in Spain, actually the most prominent investments do not come from this international or transnational investors, but actually from national groups of investors. So even if accepting the argument brought by investors against Spain on the regulatory risk of investing in Spain, it's important to remember that the country today is still in the top 10 countries where renewable investors want to invest, and energy experts consider among the essential causes that explain this improvement of the Spanish market the greater regulatory certainty and clear energy planning, and in particular, the objectives that are enshrined in the new climate change law that Spain recently approved. So there is really no mention of the ECT, and as far as we know, no real awareness that the fact that the ECT exists would make investors, be more attracted to invest in Spain. So in a way, we could say that the Energy Charter Treaty is protecting the foreign investor to obtain the benefits they expected. But what really matters for an energy investor or any investor is that there is a regulatory certainty, good planning, infrastructure, etc. And the ECT has really nothing to do with that. Another question would be if we think that the national policies are going in the right direction or not, referring to the renewable development, but that is a separate discussion that the ECT really has no influence or no say on that. So I would finish with that, yeah.
Thanks a lot. Maybe a last question to Martin. So what role could investor obligations play in any alternative to the current system, and how could they be enforced?
Thanks, Anais, for this question. So I think it goes back to the points I was trying to make on how the ECT could support domestic administrative systems to regulate energy, and how it could support domestic court systems to enforce energy regulation. So obligations on investors, whether it's to ensure that their conduct is in line with climate goals and climate policy, but also other domestic and international norms on environmental protection, labor rights, land rights, other human rights. All of these could very well remain in the sphere of domestic law, applied by domestic agencies, enforced by domestic courts. The ECT could, in case, maybe provide a floor for those obligations or international standards, commitments, or guidance for states on how to implement them and enforce them through domestic laws. I don't think it would necessarily be the optimal solution to have investor obligations in the ECT itself, because I don't think it would necessarily make enforceability easier to put host states in the position of having to initiate, say, an arbitration claim against a multinational company for a violation. Host states already have their domestic legal provisions and mechanisms as well that they can rely on. So maybe we could think of international obligations, but with domestic enforcement. And one important role that the ECT as an international agreement could play is to create mechanisms to facilitate the cross-border enforcement of administrative decisions or court judgments against multinationals in their home states and in other states where multinationals have assets. A mechanism like the ICSID or the Ancestral Convention ones could be put in place. The ECT may not be the best place for this mechanism, because it should arguably apply not only to energy companies, but to all multinational companies. But the ECT could follow or even get ahead of the binding treaty on business and human rights, which is looking at establishing obligations on corporations, and also establishing jurisdiction in domestic courts globally to enforce those obligations.
Thanks a lot, Martin. I'm just looking at the questions. There are questions also in the chat. So there is a chat. Maybe arbitrators more attuned to the laws of physics and basic climate change science would render different decisions. At the end of the day, at least for non-ICS idea words, could instead courts at the place of arbitration enforcement exercise the climate change, public policy control and set aside or refuse enforce awards that do not address climate change? Does any one of you wants to reply to that question? Eleanor, I think you were speaking about changing the way arbitrators are making their decisions. If you want to go and have a try.
Sure. Let me just reread a second the question. Not to address climate change. Well, definitely, I think by having, I mean, as in any legal system, I think about, for example, in France, there are more and more trainings on criminal environmental law to the judiciary system, for example. which is good. I mean, judges need to train, and similar as judges need to train and try to and to open their knowledge or get to know more about new things that maybe were not addressed when they studied at the first time. You know, as importantly it is for arbitrators to do so. Now, the problem I think with arbitration in part is that the arbitrators, legally speaking, they are not bound by each other's decision. They refer to each other in many instances, and you see contradictory decisions. Maybe Lucia can speak more about that, but as far as I understand, for example, in the Spanish cases, we have for exactly the same type of measures, completely different decisions. So is it going to be like training or addressing climate change by tribunals going to be effective? It is still very difficult to predict how it will end up, just because they're not bound by each other. It's not like if I go to the French court of appeal, for example, or any French court, and I bring a case, and I know that the last cases have been decided in a certain way for a specific legal question, I somehow have some certainty about this. In arbitration, it's completely different. Like when I look at cases, or for example, when we look at amicus curiae, for example, I have to look at arbitrators. How do they decide? How do they think about things? And it's very different from one to another. So c'est juste un peu improbable. We don't know yet. You know, will it be effective? I don't know.
Well, thanks a lot for providing a response to the question. We are running out of time. So I'd like to thanks a lot all the speakers for their great presentation. I think it's clear from the different interventions that we've heard today that there is a solid and growing consensus on the fact that the ECT is not the right tool and not the right instrument to support the energy transition, and that it, on the contrary, constitutes a serious threat to the climate, and not only to the climate, but also that the modernization process is not delivering any of the necessary outcome for the EU and its member states to comply with their international and EU climate commitments. So looking forward to further discussions with all of you and the European Commission and the member states. Thanks a lot again to all the speakers, and goodbye.